Rhode Island has a moderately regulated breaking lease framework with tenant protective elements consistent with the state's overall approach to landlord-tenant law. The governing law is found in the Rhode Island Residential Landlord and Tenant Act, Rhode Island General Laws. Title 34, Chapter 18, which provides a statutory framework for handling early lease terminations. If you're a landlord or tenant in Rhode Island, the state's small size and tight rental market create practical dynamics that significantly affect how broken leases play out. Let's start with the landlord's duty to mitigate damages. Rhode Island law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is established through both statutory interpretation of the Residential Landlord and Tenant Act and common law principles. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take the same steps to fill the vacancy that a reasonable landlord would take for any other vacant unit: advertising, showing the property, and accepting a qualified applicant who meets the landlord's legitimate screening criteria. If the landlord fails to make reasonable efforts, the departing tenant's liability for remaining rent is reduced. The departing tenant's liability is generally limited to rent for the period the unit remains vacant despite the landlord's reasonable re-rental efforts, plus the landlord's reasonable costs of re-renting, advertising, cleaning, make-ready work. Once a replacement tenant moves in and begins paying rent, the departing tenant's rent obligation ends. Rhode Island's tight rental market, particularly in Providence and the surrounding communities, generally works in favor of tenants who break leases because landlords can often re-rent quickly. In a market where demand consistently exceeds supply, extended vacancies after a broken lease are less common than in softer markets. Early termination clauses are generally enforceable in Rhode Island if they are reasonable. Rhode Island's Consumer Protection Framework, including the Deceptive Trade Practices Act, provides a basis for challenging lease provisions that are unfair or unconscionable. An early termination fee that grossly exceeds the landlord's actual or reasonably anticipated damages could be challenged. A fee of 1 to 2 months' rent with reasonable notice is typical and generally enforceable. Rhode Island courts evaluate the enforceability of early termination provisions based on whether the fee represents a reasonable estimate of anticipated damages and whether the provision functions as a legitimate liquidated damages clause rather than an unenforceable penalty. The distinction matters, and landlords should set fee amounts that bear a reasonable relationship to their actual expected losses. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Rhode Island's military population is centered around Naval Station Newport, which houses the Naval War College, Officer Candidate School, and various other Navy commands. Naval Station Newport generates significant rental demand in the Newport, Middletown, and Portsmouth areas. Military personnel at Newport typically serve assignments of 1 to 3 years, and SCRA lease terminations are a regular occurrence. Landlords in the Newport area should have a standard process for handling military lease breaks. The Rhode Island National Guard has facilities throughout the state, and Coast Guard Station Point Judith generates some demand in the South County area. Rhode Island has enacted protections for victims of domestic violence that allow early lease termination. Under Rhode Island General Laws, Section 34, 37, 4.1, and related provisions, a tenant who is a victim of domestic violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation can include a copy of a protective order, either temporary or permanent, a police report, or a written statement from a qualified domestic violence advocate or service provider. The tenant must provide reasonable written notice before the termination date. The specific notice period should be reviewed for current statutory requirements. When a domestic violence victim terminates under Rhode Island's provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee or penalty. The security deposit must be returned according to standard rules, within 20 days of the tenant vacating. Rhode Island's domestic violence provision includes privacy protections. The landlord must keep the documentation confidential and cannot disclose the tenant's status as a victim. The landlord also cannot use the domestic violence termination as a negative factor in any future rental decision. This is reinforced by Rhode Island's fair housing protections, which include housing status as a protected category. Tenants in Rhode Island may break a lease if the landlord fails to maintain habitable conditions. Under Rhode Island General Laws, Section 34(18)-22, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises in a fit and habitable condition, maintain the structural integrity and essential systems, and keep common areas in safe condition. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has remedies under the Act. The tenant must provide written notice to the landlord identifying the specific deficiency. The landlord then has a reasonable time to make the repair. The specific timeline depends on the nature and severity of the issue. If the landlord fails to act within a reasonable time, the tenant may terminate the lease. Rhode Island's Housing Code enforcement provides an additional mechanism for tenants. Tenants can contact local building inspectors or the Rhode Island Department of Health to report housing code violations. An official inspection and citation strengthens the tenant's position if they need to terminate based on habitability. The documentation from a government inspection provides objective evidence that the conditions were deficient. Rhode Island also recognizes constructive eviction as grounds for lease termination. If the landlord's failure to maintain the property or the landlord's affirmative actions, such as shutting off utilities, changing locks, or removing essential fixtures, makes the unit uninhabitable, the tenant can treat the lease as constructively terminated. The tenant must actually vacate within a reasonable time after the constructive eviction conditions arise. One important aspect of Rhode Island law that affects the breaking lease context, the state's strong anti-retaliation provisions. Under Section 34(18)-46, the landlord cannot retaliate against a tenant for exercising legal rights, including making habitability complaints, contacting code enforcement, or joining a tenant organization. The statute creates a presumption of retaliation if the landlord takes adverse action within a specified period after the tenant exercises a right. This protection means that landlords who pursue aggressive damage, claims against tenants who terminated based on legitimate habitability issues, face the risk of a retaliation counterclaim. Rhode Island has a specific provision regarding the landlord's right to enter the property after a tenant vacates, which is relevant when a tenant breaks a lease. Once the tenant has vacated and returned the keys, or once the landlord has reasonable evidence of abandonment, the landlord can enter and begin preparing the unit for re-rental. If the tenant has left personal property behind, the landlord must follow Rhode Island's abandoned property procedures before disposing of the items. From a practical standpoint, Rhode Island is the smallest state in the country, and its rental market functions almost as a single interconnected metro area centered on Providence. Providence is the dominant rental market. The economy is driven by healthcare, including Lifespan Health System and Care New England, higher education, Brown University, RISD, Johnson & Wales, Providence College, and Bryant University nearby, government, financial services, and a creative economy. Providence's rental market is tight with strong demand and limited supply. When a tenant breaks a lease in Providence, the landlord can typically re-rent within 2 to 4 weeks for a well-maintained unit in a desirable area, often faster during peak rental season. The student population in Providence is enormous relative to the city's size. The concentration of colleges and universities creates strong seasonal demand, and breaking a lease during the spring or summer when students are looking for fall housing results in quick re-rental. Mid-year breaks take longer, but are still manageable in Providence's tight market. Warwick, Cranston, and Pawtucket, the state's next largest cities, have moderate markets that share Providence's general dynamics. These communities are within easy commuting distance of Providence and benefit from the regional demand. Newport has a unique market driven by Naval Station Newport, tourism and the city's historic appeal. Military lease breaks are common in the Newport area. The seasonal tourism economy creates additional demand during the summer. A lease break in spring can be filled quickly with incoming seasonal workers or summer renters. Off-season breaks in Newport may take longer. The seasonal shore communities, including Narragansett, South Kingstown, and Westerly, have markets influenced by summer tourism and the University of Rhode Island in Kingston. URI's enrollment creates student rental demand, and the seasonal pattern means timing significantly affects re-rental speed. Woonsocket, Central Falls, and some of Rhode Island's smaller communities have more affordable markets with higher concentrations of tenants receiving housing assistance. Re-rental in these communities may take slightly longer than in Providence or the East Side, but Rhode Island's small geographic size means that virtually every community is within commuting distance of major employment centers, which supports demand. Rhode Island's small size creates a practical dynamic. Reputation matters enormously. In a state where the landlord community is interconnected and tenant advocacy organizations are accessible and responsive, how you handle broken leases directly affects your reputation. Fair, documented handling of early terminations builds trust. Aggressive, poorly documented damage claims invite complaints and legal challenges. One best practice for Rhode Island landlords include a reasonable early termination clause in your lease that reflects the local market. In Providence's tight market, a 2-month fee may be challenged as excessive if you can realistically re-rent in 2 weeks. A fee of 1 month's rent with 30 to 60 days notice is often more appropriate for Rhode Island's market, and more defensible if challenged. Calibrate the fee to your actual expected vacancy and re-rental costs. Another best practice: begin re-rental efforts immediately when you learn a tenant intends to break the lease. Rhode Island's tight market is your ally, but only if you act quickly. Document every step of your re-rental efforts. In a small state where the same judges and housing court referees see the same landlords repeatedly, demonstrating consistent, reasonable mitigation practices establishes your credibility. A third best practice: have a standard process for handling domestic violence lease terminations. When a tenant provides notice and qualifying documentation, process the termination promptly, handle the security deposit within 20 days, and maintain strict confidentiality. Rhode Island's tenant advocacy organizations, including the Rhode Island Center for Justice, are active and well-connected. Fair handling of domestic violence terminations is both a legal obligation and a professional standard. Rhode Island limits the security deposit to 1 month's rent. The deposit must be returned within 20 days of the tenant vacating. If the landlord fails to return the deposit or provide an itemized statement within 20 days, the landlord may forfeit the right to retain any portion. These rules apply whether the departure is a normal move-out or a broken lease. The 20-day clock begins when the tenant vacates and returns keys. For the complete guide to Rhode Island breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.